Everything we've discussed about the court's power rests on a single foundation, the power of judicial review. And here's the remarkable thing: that power isn't actually in the Constitution. The court claimed it for itself. Let me tell you how. Judicial review is the authority to declare acts of the legislative and executive branches unconstitutional and therefore unenforceable. And it was established in the landmark 1803 case Marbury v. Madison, in an opinion by Chief Justice John Marshall. Marshall's reasoning was a tight three-step syllogism. First, the Constitution is a supreme law that must prevail over ordinary legislative acts. Second, it is emphatically the province of the courts to interpret the law. Third, since the Constitution is law, courts must therefore interpret and apply it, including against acts of the political branches that conflict with it. From that elegant logic flowed an extraordinary power, the authority to invalidate legislation the court finds unconstitutional. It made the Supreme Court one of the most powerful judicial bodies in the world. Now, judicial review of state laws rests on a different but complementary foundation, the Supremacy Clause of Article 6, which declares the Constitution and federal law the supreme law of the land and binds state judges accordingly. So combine Marbury's assertion of review over federal legislation with the Supremacy Clause's reach over state law, and you get the full picture. Federal courts can invalidate the acts of all 50 states, and of Congress and of the President, when those acts conflict with the Constitution. Pause on how extraordinary that is. An institution whose members are unelected and serve for life can strike down the work of the elected branches. That is precisely why the legitimacy of judicial review and the proper scope of judicial interpretation remain subjects of ongoing democratic debate. It's a genuine puzzle in a democracy. But the power isn't unlimited, and the separation of powers cuts both ways. In Plot for Spendthrift Farm, the court held that Congress may not reopen final court judgments that would violate separation of powers by commanding the courts to reach a particular result. So how can the political branches respond to the court? When the court interprets a statute, Congress can simply amend the statute to change the rule going forward. But when the court interprets the Constitution, the only recourse is the cumbersome process of constitutional amendment. That distinction, statutory versus constitutional rulings, is exactly why constitutional decisions, like the ones we'll discuss next, are so enormously consequential and so hard to undo.